Hello everyone, I am Wamiq currently pursuing VLLB from Vivekanand College of Law, Aligarh. Currently I am also legal intern at LEXIS and Company. So my presentation topic is Conciliation in India. So the question arises is what is Conciliation in ADR? So the Arbitration and Conciliation Act 1996 deals with domestic arbitration and conciliation proceedings. Conciliation is an alternative dispute resolution system out of court. In conciliation, parties are free to attempt and agree to resolve their dispute. Therefore, there are two types of conciliation: voluntary conciliation and compulsory conciliation. What is conciliation in IDR? Meaning conciliation means settling dispute without litigation. Conciliation is an alternative dispute resolution whereby a third party, therefore conciliator, meets the parties to resolve their differences and settle the dispute. Kinds of conciliation: voluntary conciliation. In voluntary conciliation, parties are voluntarily participate in settling their dispute. Second, compulsory conciliation. In compulsory conciliation, parties do not want to participate in parties do not want to meet the other party to settle the dispute. Then the compulsory conciliation method is used. In labor cases, the compulsory conciliation method is commonly used. Application and scope of conciliation. Section 61. Section 61 of the Arbitration and Conciliation Act of 1996 deals with the application and scope of conciliation. It applies only those disputes submitted to conciliation which dispute not submitted to conciliation, then it not apply. Commencement of conciliation proceedings. Section 62. The initiating conciliation party shall send to another party a written invitation for conciliation. Writer invitation contains the briefly and identify the subject of dispute. When another party accepts the invitation, then conciliation proceeding shall commence. Conciliation proceeding shall not commence when other party rejects the invitation. If initiating party does not receive a reply within 30 days from the date on which he sends the invitation or within the period as mentioned in the invitation, then he may elect this is a rejection of conciliation, and if he so elects, then he shall inform in writing the other party. The numbers of conciliators. Section 63. There shall be one conciliator if the parties agree that there shall be 2 or 3 conciliators. Where there is more than one conciliator, they must act jointly according to the general rule. Appointment of conciliators. Both the parties may agree on the name of a sole conciliator. Second, there are 2 conciliators, then each party may appoint one conciliator in conciliation proceedings. Third, there are 3 conciliators, then each party may appoint one conciliator, and both parties may agree on the name of the third conciliator who shall act as the presiding conciliator. The parties may enlist the help of the appropriate organization or individual in the appointment of conciliator. The parties may request such organization or person to recommend the names of suitable persons to act as a conciliator. Duties and powers of conciliator. Submission of statements to conciliator. Section 65. After the appointment of conciliator, he may request both parties to submit to him a brief written statement describing the issues and general nature of the dispute. At any stage of conciliation, the conciliator may request a party to submit additional information to him. Conciliator not bound by certain enactment. Section 66. Conciliator is not bound by the Code of Civil Procedure 98 or Indian Evidence Act 1872. Role of conciliator. Section 67. The conciliator shall assist the parties independently and impartially and reach an amicable settlement of their dispute. In conciliation proceedings at any stage, conciliator propose settlement at any dispute. Suggestion by parties. Settlement of dispute. Section 72. The settlement agreement. Section 73. When parties reach an agreement and settlement of the dispute, then parties may drop and sign a detailed settlement agreement. It shall be the final and binding on the parties. Role of conciliator in the other proceedings. Section 80. Agreed by the parties in any arbitral tribunal or judicial proceedings, conciliator shall not be presented by the parties as a witness, and he shall not act as an arbitrator or as a representative or counsel of party. Section 81. Admissibility of evidence in other proceedings. So this is all about conciliation in India. So please like this video and share this video and subscribe the LEXIS and Company Law Firm channel. Thank you and have a nice day.